Even with the
There was
series,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah, go ahead with your response.
Even
Court calls the case, People versus Joshua Smith.
ready, Your Honor.
Oh.
Hey, good morning, Your Honor. Miles Drew on behalf of Mr. Joshua Smith, who I believe will be approaching my right any moment. The court should have an executed substitution of counsel in this matter.
Where's your client?
Mr. Smith is in custody, so I believe the deputy should be bringing him out any moment. Mr. Smith, once you get to the podium, could you please state your name for the record?
Joshua Smith.
Thank you.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam Prosecutor.
Is this the only thing holding him?
I'm sorry, Your Honor.
It's the only thing holding him?
Yes, it is, Your Honor. We would like to address the matter of bond when the court is ready.
Cause conference, July 11th,
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Mr. Smith and help in any way they can. His mom is a assistant deputy director of field operations for the Michigan Department of Correction, essentially in charge of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter, Judge, and I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a probation sentence.
I understand how sentencing works. Go ahead, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Your Honor, we originally requested a $75,000 cash as surety in this case, and we were given $75,000 with 10% privilege. This is a case that was completely captured on video. The defendant is a teacher at Ypsilanti, was a teacher at Ypsilanti High School. The victim in this case was a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old space and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right. So I'm significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the
There was
serious,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah,
And
go ahead with your response.
even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest, where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.
I understand, Judge.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.
Court does call the case, People State of Michigan versus Montel Bennett.
The Michigan Office of People.
And good morning, Your Honor. Ben Denner with Assistant Public Defender on behalf of Mr. Bennett, who is appearing from the Oakland County Jail on the court Zoom feed.
Yes. Mr. Bennett, can you state your name, please, sir?
Montel Devontae Bennett.
Thank you. All right, what are we doing on this?
Your Honor, yesterday I emailed a plea form to the clerk of the court that was signed electronically by APA Ganatra and myself.
Is that what we're doing today?
Yes.
All right, the court does have before it a plea form. Plea form indicates that the defendant would be pleading guilty to an added count to a false pretense is 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, count one would be dismissed. And there is an agreement that the defendant would pay restitution in the amount of $694.35. That's the court's full understanding of the agreement.
That's correct.
Yes, Your Honor.
All right, very good. Mr. Bennett, can you raise your right hand, please, sir? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name again for the record, please.
Montel Devontae Bennett.
Mr. Bennett, it is this court's understanding that you're going to plead guilty. You can put your hand down. That you're going to plead guilty to the charge of false pretenses 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty to this charge?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
of your own free will.
Yes.
And because you believe that you're indeed guilty of this offense?
Yes.
October 28, 2023, at the location of 813 West Michigan Avenue in the city of Saline, Washtenaw County, state of Michigan, what'd you do that makes you think that you're guilty of this offense?
Cash the fraudulent check.
Okay, where'd you cash it?
And saline.
Okay, and that was a check that was made out by McDonald's?
Yes.
All right, and you knew that it was fraudulent at the time that you did that?
Yes.
And when you cashed the check, did you receive either in goods or in cash over $200?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be
July 2nd at 9 a.m. before the rush hour.
Is that going to be enough time?
There's a writ, is this a writ case you're on?
Yeah, it is, and I don't think that's going to be enough time. Is that the only date you
That's
have?
the only maybe that for the next would be August 27th. That's around the same date.
All right, sir. Is there any anticipation that you'll be released from Oakland County anytime soon?
No, I'll probably get 10 months here. I did a college agreement for 10 months.
You got 4 months to go.
Yes.
All right. Here's what I'm going to do. They may move your date up, but August what?
27th at 9 a.m.
I'm going to set your date for August 27th, 2024 at 9 a.m. Like I said, they may move your date up on this, okay?
Okay.
All right. Bond will continue. Thank you.
Thank you, Judge.
Thank
Court does call the case of the people versus Gregory Williams.
David I. Goldstein appearing on behalf of the defendant,
Your name? Gregory Williams. What are we doing?
sitting for an exam, Your Honor.
Discovery complete on this one?
As far as I know, yes, Your Honor.
People have their witnesses available on the 9th.
We'll do our best.
Preliminary examination
That date's fine, Your Honor. Thank you.
in person will be set July 9th, 2024, 9 a.m. That is before Judge Burke.
Your Honor, I'd like to address the court very briefly on the issue of bond. When bond was set in this matter, Mr. Williams was ordered for a GPS tether. I would indicate to the court that I represented Mr. Williams in a certain court matter that went for over a year. It was ultimately dismissed by the people. And there was never a problem with him on bond. He wasn't on a tether on that one, but there was never any issue with him appearing. There was no complaints about his behavior or anything else like that. Given the nature of the charge in this case, and given the fact that he has never had a problem with complying with the court's bond, we're asking the court to drop the GPS tether requirement.
Is the GPS a location tracking? Or?
That's right. Tracking location?
Yeah.
Yes.
Response from the people.
Your Honor, I would be opposed to that. In this case, it is a DV case. The standard, as far as I'm aware, in DV cases, but more than that, the defendant and the victim got into an argument over child custody issues and court related to the child custody. The defendant got upset at the victim as well as other passengers in the vehicle, and he attempted to run them off the road and made an abrupt stop, causing the next word and hit them behind another car. Both the victim, who is the domestic violence, or who is he has a romantic partner with, as well as one of her friends, and their children were in the vehicle at the time. I am extremely concerned at the nature of this case, and I would be opposed to modifying. He's already out. I think a GPS tether is appropriate.
Your Honor, if I could address briefly, because I made a mistake. He's on a house arrest. We're asking the court to make it a GPS location. At least he was told by the tether people there was. My notes don't reflect that from his arraignment, but he was told by the tether people
That he's on I do have him on a home confinement tether.
request $100,000 at the outset. We would prefer to state custody. I think home confinement is appropriate.
Well, they set it at 50. He posted, when is the exam set? On the 9th. At this point, I understand your position, Mr. Goldstein, but what I'll do is I'm gonna leave what is in place, let the exam happen, let Judge Burke make that decision after. So I'm gonna deny your motion at this time.
Thank you, Your Honor. That's Judge Burke.
Yes, that is before Judge Burke.
Your Honor, may I approach the bench briefly with Ms. Hughes?
Yeah, because I don't have anything else to do. Come on. Court calls the cases of the people versus Regina Brown. These cases.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Brown.
What are we doing?
Your Honor, this time, we are still in the process of plea negotiations. We're hoping for some sort of specialty court resolution. We would like to address bond and as well as get an adjournment.
How much time are you going to need to try to get all of that done? She's got 8 cases, I think, here.
That is correct, Your Honor. The last communication I had with the prosecutor's office, they were doing some internal discussion as to whether or not they would agree to the referral to the specialty court. So with that,
July
I've asked for-
18th, 2024, 9 a.m. as to bond.
Your Honor, we, Miss Brown is a community mental health, pardon me. Okay. She is a community mental health customer. She is also, if you look at the dates, most of these are, some of them are quite old. All of these incidents occurred around the same time or in that same time frame as right after her mom's death, as well as her son being diagnosed with stage 4 renal failure, as well as her house being on fire. Prior to that, she had had at least a year of sobriety. She had her own home. She was working, and she went back to her mom's home in order to take care of her. And that was a very big trigger. At this time, she is working very hard and has made some good progress towards getting her life together. She does have her own place. She's been working with Avalon Housing and recently got that. She's recently reconnected with community mental health. She would like to, if the court would consider allowing the opportunity for her to return home with a tether, she would have no objection, and to begin to get into some sort of treatment that way.
Any response from the people?
And there's a bond recommendation form filled out by Assistant Prosecutor Rachel McDuffie. And if the court has had a chance to review that or has it in the file, the prosecutor there outlined flight risk and dangerous driving aspects of the defendant's behavior over the last few years. And included in that summary, Your Honor, and I'm not going to go through everything because I know you've had a chance to review it. While on bench warrant status here for the Washington County cases, she entered a guilty plea to operating while under the influence of drugs in 34th District Court, February 17, 2023, and has another bench warrant for failure to comply with the PSI on that misdemeanor case. So there's a lot going on with her, and I just don't think it's a good decision right now to release her to the community, especially if they're contemplating some type of treatment or specialty court. She needs a lot of services in place to support her before we can let her go back.
And she was before me, I think, yesterday on this case, and so I'm actually very familiar with this defendant. And at this time, I'm going to deny the motion for any type of bond reduction. There'll be no release. Get this worked out and make sure that everything's in place for her. All right. The motion for bond reduction tonight, July 18th, 2024, 9 a.m. Bond continued. Court calls case People versus Michelle Knoll.
Joy Gaines, Senior Assistant Public Defender, representing Ms. Knoll.
Her name, ma'am?
Knoll.
All right.
Your Honor, we actually have come to a resolution in this matter. We had been waiting, and our office had been told by the 14A sobriety court that they would not be able to evaluate It's null for eligibility until Friday. They were able to get out yesterday to evaluate her and accepted her and had a plan. However, because of the information that we originally received yesterday, there's not a plea form available. And therefore, that's why she is very upset, because we will need to request an agreement. But we do have an agreement and a plan.
All right. So she's crying because she wants to get this done today.
I'm sorry.
Is that right?
I have something I'd like to speak on if you'd allow me to.
Okay, go ahead.
Thank you. I just want to thank you for letting me to speak on this matter. I just wanted to let you know that I did put myself in inpatient treatment after my setback with my bond violation. And I was in contact with community corrections to inform them that I was going to inpatient treatment in Bear River Health in Gaylord. And I completed treatment, and immediately after completing treatment, I turned myself in to Washington County Jail. And I have taken accountability, and I understand the seriousness of my setback, Your Honor. And I'm just requesting to be released under any conditions to handle my obligations and waiting sentencing and to enter sobriety court. I'm sincerely asking for your mercy and compassion, because part of my obligations is to be there for my mother in hospice care. And I have lots of support that would help me with this, but as you know, hospice care is the end stage of life. But I am, however, looking forward to beginning sobriety court and continuing with my recovery plan in a new phase of my life. Thank you.
You're welcome. Okay, what we'll do is, if it's just a matter of getting the plea forms, everything else is in place. Today's what, 27, so we'll put it out 5 days. I happen to have July 2nd. So we'll just put it out 5 days, get the forms in, then we can get it taken care of and try to get her moving on her way. Okay, fair enough?
Thank you.
July 2nd, 9 a.m., bond continued. Thank you.
Ms. Gaines and I approach.
Yes, sir.
Witness closed.
Court does call the case, People versus Keelan Harris. You gotta go to that side. All right, go ahead.
Good morning, Your Honor. Deborah Geraldine Bledsoe Ford on behalf of Keelan Harris, who stands to my right.
Your name? Sheila Harris. All right, what are we doing?
We're asking for an adjournment. I just got appointed on this matter. I ordered discovery, don't have it. So I'd like to share the discovery with him, and I expect that we will hold the preliminary exam.
Probable cause conference, July 11th, 2024,
Thank you.
9 a.m. bond continued. Thank you.
Oh, excuse me. He did ask me to address bond. He wanted me to tell you that he, I believe, has had one prior UIL, was on probation for it in Clinton Township, was in compliance with it, that this matter emanated from his baby's mama, and that he feels that it's contrived, and he stands in not guilty plea, and that he is employed as a chef at a Bebo Restaurant Bar and Grill in Mount Clemens. His boss is Scott, and this can be confirmed. He was working at the time of his arrest. Is that correct? Anything else?
I'm sure there's a response. Go ahead, Ms. Blanche.
He actually has a 2019 conviction for reckless use of a firearm. He also has an OWI from 23. There's a couple of things like Grosse Pointe, Easton, Westland, and Home.
Can I just holds for holds or arrests or contacts? I know holds as in he's evaded court. Or
no, like they have probably there's warrants out for various tickets.
Traffic.
I don't know. I can look up in a second.
All right. Well, traffic.
Judge, he has, we requested a $200,000 bond on this matter. The magistrate at the time gave 100,000, 10%. This case, I was extremely concerned. I was the one that wrote the warrant on this case. He actually took his car with his minor children in it and hit the victim in this case and tried to run into a truck on the highway. When he pulled off the highway, stopped at a gas station, he then tried to pin her up and run her into the pumps in the gas station. The kids were in the car. The kids are all both under 2 years old. Extremely concerned. So I asked you not to change bond. We had asked for a higher bond. I think that would have been warranted.
He says that those allegations are contrived and that at the video at the gas station can substantiate it, that she was nowhere near him when he accidentally had the car in reverse. She wasn't. It's
He
saying,
accidentally put the car in reverse.
no, it was already in reverse.
Oh,
It was already in reverse. He says that the video will substantiate that and she was nowhere nearby.
okay. Anything else?
No,
Motion for bond reduction denied. Bond will continue.
thank you.
Court does call the case. People versus Jabari Harris. Yeah.
Good afternoon, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Harris, whom I don't see here. I believe he's playing Pac-Man, Your Honor, and that he's ghosted us.
Okay. I don't even know what to do with that. I mean, I understand what you're telling me. I did order him to be here at 1 o'clock, given what the bench warrant will issue for defendant's failure to appear for this hearing. And given the allegations in the bond violation, bond will be set at this point at no bond.
Thank you, Your Honor.
Judges, the plenary exam.
Pardon? I have not said it. I've not said anything.
Thank you.
Calls the case, People versus Jessica Mullen.
Good morning, Attorney Kevin Basant, P71061 on behalf of Jessica Mullins, who I would ask if her appearance could be waived for the purposes of today's hearing, Judge. And
I'm not waiving any. Why am I waiving her appearance?
Because Judge, she's in Sacred Heart treatment facility in Richmond, Michigan. At our last hearing, she had tested positive for meth. I informed the court that we were in the process of getting her into Sacred Heart. She did check into Sacred Heart last Thursday. My only issue is that I'm running into a problem with Sacred Heart in terms of them giving me a letter of admittance showing that she's there. But she is enrolled in a 28-day detox program right now at Sacred Heart in Richmond, Michigan. And I would just ask the court for time to provide that proof to the court. But that's why she's not here today, Your Honor, because she is in Sacred Heart 28-day detox program.
Any response on that from the people?
If we could just try to get that confirmation from Sacred Heart. Last time we were here, talked about Sacred Heart. The court asked for confirmation that she was there. We still don't have that. What we do have instead is an updated community corrections violation report.
Right.
For her missed test, she was testing positive for things that she did not have prescriptions for, and a MAPS review indicated there was no prescription that would cause these positive tests. So without confirmation, it's really questionable.
And we don't have a confirmation. Why, counsel?
I've asked for that letter from Sacred Heart. They say that they can give it to me. They had to get her permission first for a release form. I've submitted that release form. I've not received a response back from Sacred Heart, but I'm in the process of doing that, Judge, even if I have to, I guess, issue a subpoena for them to get it. But that's
July
why my
11,
client is not here.
2000. I'll adjourn it out to July 11, 2024, 9 a.m. We'll need proof at that time, or she needs to be here.
Thank you, Your Honor.
Okay. Thank you, Judge. Thank you.
Court does call the cases of the People versus Ian Beck, Timothy Marvin, Edwin Traeger, and is it Gabriel? Is it Vieira?
Andrew Childers. May it please the court, Doug Malkoff. I represent Ed Traeger. I'm also, with permission of defendant Gabriel Vieira, standing in for John Minnock, and with permission of Timothy Marvin, standing in place of his attorney, Jamil Kuja.
The individuals that are not normally represented by Mr. Malkoff, do either of you have an objection to Mr. Malkoff standing in for it?
No.
No, Your Honor.
All right, thank you.
Good morning, Your Honor. Allison Krieger for Mr. Beck, who is behind me.
Okay. All right. Almost afraid to ask. What are we doing?
Mr. Childers?
It's your show, Mr. Malkoff.
Mr. Childers has met with the defense attorneys, and we have been discussing a swift resolution of this matter. However, swift is not as swift as I had hoped, and it is the agreement of the parties that if we could adjourn the PCC out to your July 18 date, we hopefully will have news to report to you.
That's all correct.
Your Honor, I as I relate to Mr. Molkov, I start a murder trial on July 15th, but Mr. Beck is in capable hands, and with his permission, one of the other lawyers can stand in for me.
Probable cause conference in these matters will be adjourned July 18th, 2024, 9 a.m. Bond will continue.
Thank you, Judge.
Your Honor.
Thank you. Court calls the case People versus Charles Johnson.
Okay,
Those are
them.
Good morning, Your Honor. Assistant Prosecuting Attorney Sophia Curry appearing on behalf of the people. Oh, sorry.
Yeah, you probably don't want to be up at the podium.
Assistant
ahead.
Public Defender Constable Basie on behalf of Charles Johnson, who was present to my right. Can you state your full name for the record, please? Mr. Johnson.
Charles Bernard Johnson, second.
Thank you.
Your Honor, today is the date and time set for a probable cause conference. I have reached out to the agency for an offer. We are still in negotiations, so I would just ask for a brief adjournment in this matter.
No objection.
And I would also like to address bond.
Of course you would. Probable cause conference will be adjourned July 11th, 2024, 9 a.m. As to bond.
Your Honor, in this matter, I would just ask that my client be allowed to be released to treatment if he gets a spot in treatment.
Any objection from the people?
Your Honor, the only concern or the only thing I would ask is that it would be a treatment center that he's just not able to walk away from. So something inpatient where he just can't sign himself out.
No objections, Your Honor.
All right. Brendan may be released to an inpatient treatment program on a PR. Otherwise, bond will continue. Thank you.
What judge did you say, Your Honor? I'm sorry.
Pardon?
Which judge in front of you?
What was the date, Your Honor?
July 11th, 9 a.m.
Yeah, I'll be here. It's me.
Thank you, Your Honor.
And you just fill out that order. Court calls case People versus Cherie Nally.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Nally. Your Honor, we have begun negotiations with the prosecutor's office. It's my understanding that they have charged 2 more cases and that there may be a third that will be coming. We are requesting an adjournment. We would also like to address treatment for Ms. Nally. Prior to being arrested, she had been on the wait list for Oakdale Recovery. We're requesting a release to treatment if we're able to confirm that and get her into.
Well, where are we with the other cases, I guess?
2 cases were signed and authorized yesterday. Each case has the same 2 counts with different offense dates, both for April. Count 1 is larceny in a building. Count 2 is larceny under 2,000. There is a 3rd case that I'm waiting on additional information from law enforcement on, which has potential additional felony counts, including financial transaction device, additional receiving and concealing, as well as larceny charges on that one. I have not made a charging decision because I don't have all of the information on that one yet, but I do know for certain there are 2 additional felony cases that are coming that were authorized yesterday. I would anticipate that since she's in custody, they will be sworn out before the next PCC.
Court calls case People versus Candace Anderson.
Thank you, Your Honor. Assistant Public Defender Constable Basie on behalf of Candace Anderson. To my right, Ms. Anderson, could you go ahead and state your full name for the record?
Candace Anderson.
Thank you.
Your Honor, today is the date and time set for PCC. At this time, we will be respectfully requesting to set for exam.
Folks, hold on a second. The individual in the wheelchair should have that first seat in the back. It's designed for that. So that space is designed for you right there. Got it? Perfect. Thank you. Go ahead.
Yes, Your Honor, we'd be respectfully requesting to set for preliminary exam at this time.
And discovery is complete.
Yes.
Yes.
People have their witnesses available the 9th. Preliminary examination in person, July 9th, 2024, 9 a.m. That's before Judge Burke. Bond continued.
Thank you, Your Honor.
Not as a permanent decision. I'm going to deny your request at this time. Let's try to get her arraigned on the other 2 to try to put everything together. And I'll put this out to the 11th, July 11th, 2024 at 9 a.m. Bond will continue then on this matter. And Miss Michael, can you check? You said you don't know if they've been sworn out yet.
They were signed yesterday, so I'm not sure if they would have been, if they were sworn out, they would have been sworn out this morning, would be my bet.
Okay, can we somehow or another try to flag something so that all of these get put together if they're coming down the pipe? Thank you. Court calls case People versus Avion Johnson.
Assistant Public Defender Chelsea Virgilis with an Johnson, please state your name.
Avion Johnson. All right, what are we doing?
You would ask to set this for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 9th. Preliminary examination in person, July 9th, 2024, 9 a.m. before me. Bond continue. Thank you. Court calls the case, People versus Wardell Smith.
Good morning, Judge. Robert J. Kill on behalf of Wardell Smith. Judge, just a couple things.
Like a client?
He just called me. Yeah, he just called me, said he's running a little late, but I would ask the court if we could just please pass this. I'd greatly appreciate it. So would my client. You being the understanding judge.
What?
You being the understanding judge, I would ask you to please pass this.
Yeah, that ended yesterday. I'll pass it.
Thank you.
Court does call the case, People versus Ronell Johnson.
Morning, Your Honor. Michael Doby for the people.
Good morning, Your Honor. Erica Julian appearing on behalf of Mr. Johnson. Ronell, can you state your name for the record, please?
Ronell Johnson. Hold on a second. That's the whole courtroom clearing.
Thank you, Your Honor. This is time and date obviously set for PCC. Mr. Doby and I have already been in communication about the case. There's still some additional discovery and investigation that needs to be conducted. We're asking for an adjournment.
How much more time do you need?
I would think a standard couple weeks, and then we can see where we still are from there, Mr. Doby, or would you like more time?
Yeah, I'd say the 11th or the 18th.
Okay, those were going to be your choices. Which one do you want?
The 18th, Your Honor.
July 18th, 2024, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Court calls case, People versus Tila Stevens.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Ms. Stevens this morning. Ms. Stevens, can you turn on your camera and state your name for the record?
Tila Stevens.
Thank you. Your Honor, today is date and time set for a probable cause conference. Mr. Ganatra and I have had an opportunity to discuss this matter. Your Honor, we're seeking a 4-week adjournment. I believe we do have a resolution.
4 weeks out, July 25th.
It's a good date, Your Honor.
Probable cause, July 25th, 2024, 9 a.m. Bond continue.
Thank you so much, Judge.
Thank you. Court calls case, People versus Shanquez Lawson.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Lawson.
This is, you're face this way. You're withdrawing.
Yes, Your Honor.
Counsel that would represent this gentleman was signed in. She has signed off and then she's coming back. She was called to another courtroom. Let's take him back and I will grant it once she's here on your motion. Okay.
I'll be here.
All right. Court calls the case, People versus Omar Alahari.
Attorney Feaster on behalf of the defendant, who I do not believe is present with us today, Judge. For the record, I don't know why he is not present. I have made calls and sent emails. I will, for the record, request an adjournment. I do not know where he is, Judge.
Alahari. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of $10,000. Cash surety. That warrant will issue immediately.
Thank you, Judge.
Court calls case, People versus, is it Allen, Jameson Mitchell?
Jessica Blanche, appearing on behalf of
Your Honor, this is a probable cause conference. There is some outstanding body cam footage I've requested. I believe I will have that shortly or in a couple days. I'd ask for a new adjourned date.
Probable cause conference will be adjourned July 11th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
I'm ready on this one. Court calls case, People versus Trevlin Allen.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Allen, who should be present via Zoom.
Sir, state your name.
Trevlin J. Allen.
Thank you, Your Honor. We are respectfully requesting a brief adjournment of this matter to further review discovery.
July 11th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
What I'll do at this time, then, I don't know if they're going to be able to get them done by the 11th, but I'm going to